Yes.
Sir, मतलब, just to confirm, मतलब, on that, on premises of February, मतलब, it was listed, but मतलब, the lawsuit within bench, मतलब, petition could not. I pray this matter will be listed on the 11th of March, month.
Please. So documentation account number 7. Matter of concern and yeah. Now, I try to engage in
The respondent,
Time period for the inform. On behalf of STL,
any objection? Then why are you not arguing the matter?
what happened? Kerala law. I have to open some instruction. Like that, I will hear this. Hearing order is there.
Staying in the same boat.
Continue to take steps on that address. That happened earlier that when I was looking at the picture, the other side had furnished the address in the course of the motion, what she records. So probably they can say
Pension matter. Pension.
not pension, the amounts lying in the bank not being released. We wanted a portion to release. That's tomorrow. Tomorrow it happens when Lordship would allow that, then the steps would go. And accordingly on 13th, that can be posted another 2 weeks down. We can have the meeting.
Only.
Okay.
Tomorrow, let it be on Monday. Monday.
Item number 9. Daily. I'm for the petition. I'm getting it. They want some. Yes.
Some interim order is there.
I think item number 36 Lord. That's right. This time, a favor petitioner will file a even reply. Which time for kindly.
It is pending.
Yes.
10 to 32. So, seven.
So item number 4. 14 weeks to file RFP.
You're for the
Corporation department, not for the rest.
department.
Corporation department.
Corporation department.
I put a petition.
Yes.
And then
Madam, my lord. Already is at page 32, my lord. As per, serial number E. Transfer from Nalbari to Dibrugarh, just on completion of 2 years, my lord. Although it is required to be transferred after 3 years. My lord, the heart patient, my lord. Here, granted, my lord, ICD, my lord. Lordship that I have imaged the certificate at page 39. There, my lord, page 39. This was certified that Dr. Deepak Kumar Das, MBBS Microbiology, Professor of Deepu Medical College and Hospital, Karni Anglo, being permanent Gauhati, and undergone a treatment of obstructive hypertrophic cardiomyopathy, mild scar buds also.
He is not advised bed rest.
He's advised, not, he's not advised to get this, my lord, but he's been, advised to join his duty after 2 weeks. Then, my lord, then he should avoid long journey, not more than 2 hours journey continuously. He should monitor at regular interval at any country.
Where are you reading this?
But page 39, my lord. Number 1 and number 2, my lord. 39. 40 is the certificate from my lord. Hyderabad, my lord. Both. First one is at around 2015.
Yes, respondent, what did you say?
And my son is also, my lord, appearing in class 7 examination and final exams are going on. And my lord, I mentioned that, my lord, he had a night problem, my lord. He had to take oxygen by artificial breathing.
Yes, Mr. Bola.
My lord, regarding his representation, because now my lord,
You consider, have you filed any representation?
Yes, immediately, my lord. On same day.
Where is that?
That is, my lord, at page 34.
Yes, my lord, that will be considered, but otherwise, my lord, the law says that, my lord, we should first join his, my lord, and thereafter, respondent may consider. And otherwise, my lord,
Infraction of anything, it's a case on health grounds.
he is a doctor, he has been transferred to Dibrugarh, which is a pioneer health
No,
institute.
but how will we go there? Are you providing airfare? Air ticket.
That, my lord, because the Saxena judgment, my lord, that also says that first he should join. And otherwise, my lord, the person who has been posted in the place of the
You
petitioner.
examine his case,
Yes, my lord, it will
his
be
medical condition,
Yes, my lord.
and then you pass appropriate order.
Yes, my lord, that may be passed.
This is
But
a matter where
that, my lord, but otherwise, my lord, the person who has been posted in his place, that person has joined already.
No.
Joined, my lord. Just now, I have received the instruction from the principal of Nalbari Medical College, my lord.
consider his application.
Yes, my lord, that may be considered. But
Mr.
the,
Roy.
My lord,
Otherwise, the law is clear that you have to go and join and then
my lord, for our inspection, either he has been released, either he has
No,
been
my lord.
released
the
because he is
order,
on leave, my lord, for 5 days.
no, order says, my lord, all the incumbents were,
there is a circular, I think.
and the expense released with
There is a
immediate
circular-
effect.
there is a circular of the government.
Otherwise, also the order itself says, page 32, my lord, doctor's concerns then released with immediate effect. The order itself says, my lord. Yes, my
From the
lord.
point of the
Representation may be examined, my
health
lord. Yes.
concern.
And secondly, my lord, his wife is also Haju working, my lord. So husband and wife, my lord, now he is the most medical in case of emergency, and that is the problem, my lord, joining in Dibrugarh alone, my lord. I have stated
You
in para 9.
ventilate your grievances by way of this, we have already done it, and allow his, allow him to furnish
That means we want to.
Type two.
We'll send the mail also.
C. ID.
Legal education and research department.
Medical education. Then,
Section my lord, 2006 9 FCC 583.
6, 9. summary.
Current secretary. Okay. But my lord, in this place, new incumbent has already joined.
Side. Liberty to side. Taking anything.
Obligement.
IA.
Required.
Objection.
Nine lordship. 9, 10 lordship.
Nine.
Everything is done.
After. Seven. Marks.
Yes.
Query was as to when did the petitioner got the termination order? Query raised by this honorable. Is on 20 order only on 20.
Then you were served with some letter.
we have taken a broad stand, my lord, stating in detail, my lord, as to how the notices could not be served on the petitioner because of his prolonged actions. And thereafter,
So the query was
yes,
that say not serve the notices, right? Seek the termination.
yes, sir.
And your reply is that this is on in respect of the come to page number 9.
Page number 9.
Yes, sir. There you have specifically mentioned the number and date of the termination.
Thank you.
I know, but how have you where have you stated in the writ petition?
Yes, I have stated it in page 6, my lord. Page 6, I have stated it. Starting from after developed from her health condition, he went back to Guwahati and went to office on.
Where is that letter that you came to know that you were terminated?
That letter is not.
What were you suffering from? Where is that?
Prices are starts from annexes to page 14. Price
So,
to
Mr. Any appeal filed again?
File any appeal, they have only made file a representation, my lord. Petitioner had filed a representation that lordship will find at my lord page my lord page 22. And it's page 22, my lord. Out of the representation, prayer for modification, alteration of order dated 14/2018. Not in the nature of his statutory action, my lord. He has just made a prayer, my lord, that
Any
so in fact I have secured the records also, my lord. The records also do not suggest, my lord, that any order has been filed. What
be the appellate authority?
appellate authority will be, my lord, here, my lord, it will be, my lord, the Commissioner Secretary Finance Department. Because this is only a representation, Lord, you will kindly see. So kindly see, my lord, the order at page 20, for a moment, my lord. Order at page 20 that has been, my lord, issued by the disciplinary authority. That is, my lord, the Director of Accounts and Treasury. So naturally, my lord, the appeal has to be filed before the higher authority under the 64 rules. So higher authority in the instant case, my lord, the Commissioner and Secretary, the Government of the Finance Department. Having not done so, the petitioner has only filed a representation. And my lord, in the affidavit, my lord, which has been filed by the Directorate of Accounts and Treasury, my lord, against the statement made in paragraph 6, my lord, 5, 6, and 7, my lord, it has been stated, my lord, that there are no records. In fact, there are no records in the department so that, my lord, this representation was filed at all. this representation was filed. So this is the technique. And when the purpose notice was issued, the presenting officer was appointed, then the inquiry officer was appointed. Hearing notices were issued one after another to the writ petitioners for registered post, which were not delivered and which have been returned, answers stating that, it has been received. All that has been annexed to the affidavit in opposition. And then, at one point of time, the department had to resort, to go for newspaper publication. Newspaper publication, Lordship will find, in the affidavit.
But
Because
he claims to be subject.
yeah, person may suffer from any disease, but there is a issue where this honorable court is examining whether, that he has, culminated in accordance with law. Now we have issued the so-called notice. We have, appointed the presenting officer. We had appointed the inquiry officer, and he had not participated in the disciplinary procedure. Not at all. Not on even on a single day. He was called again and again, one after another notices. And thereafter, at one point of time, the department had even gone to resort, to for newspaper publication, which Lordship will see, kindly see at page 19 of my affidavit, page 19,
Who was there any
inquiry report. Inquiry report has not been endorsed, but it is available in the record, it was the original record. Findings are there, and on the strength of the findings, he has been terminated on account of prolonged absence. And kindly see, in the affidavit, he has stated, in tabular form, in what manner he had remained absent during his service period. For a moment, if Lordship comes to, to our affidavit, it's the only affidavit filed, The affidavit in opposition, filed by the respondent number 2. That is, the Director of Accounts and Treasury.
You did not ask for the inquiry report.
Ex parte order.
You obtain
Ex parte on the face of the record, we admit it,
My humble prayer. I participate this time. Yes, I did not receive anything. I was in my
we have no option but to proceed.
was my condition, my lord.
Certificates.
Original record which I have secured, doesn't speak so much. Can he remain silent? In fact, he was aloof, He remained aloof. So under that circumstances, the department had no other option but to go for even newspaper publication. What can we do, one after another? Entire flow of events have been spelled out in my affidavit. It's detailed. entire flow of events. And my lord, the manner in which my lord the petitioner remained absent is called out my lord at paragraph 12 of my affidavit in opposition. Paragraph 12 of my affidavit in opposition, my lord. He was appointed on 7th of July, 7th July 2010, my lord. That is annexure A to the petition on grade 4 post on temporary basis. Was having been appointed on 7th of July 2010, kindly see, my lord, how he remained absent. From 7/3/2011 to 5/4/29 days, then my lord 19 days, then 4 days, then my lord 509 days. Absolute my lord unauthorized absence. Prediction of duty, insubordination, whatever name we call, my lord.
What's it? Potential.
Departmental proceeding. I mean,
When did you,
when to office on? Six, my lord.
509 days you were absent? Yeah, rapidly.
509 days still, my lord, from 21/11/2014.
They are
13
counting
for
all along, my
2016.
lord, from the first
Definitely.
time of joining, my lord.
Definitely is a government servant.
They are counting from the first one. But unauthorized absence is only for one person.
Right from service failure, my lord, he had chosen to remain unauthorizedly absent. Warnings were issued, letters were issued, everything has been spelled out in my affidavit. Nonetheless, my lord, he continued to remain absent unauthorizedly. At one point of time, my lord, having reached a stage, my lord, where his absence was of that nature, of that magnitude, my lord, where the department had no other, my lord, option but to take it all on DP. And therefore, my lord, this so-called notice was issued. He had not even bothered to file a written, my lord, written statement or reply against the so-called notice. It is case, my lord, that he has not received this so-called notice. Everything has been annexed to the writ petition. Kindly see, my lord. Everything has been annexed to the writ petition. How he received, how he has received it, how he has received the so-called notice, my lord. Everything is called up. And my lord, at paragraph,
When did you join?
Year 2010.
Recovery.
Let me join, my lord.
After recovery, when did you go?
4 2008.
17. 17. Certificate provided by you. certificate. Said to join in 2018.
I suffered from my condition was 19 also reflects 2016.
But you come to page number 19 also. There also it says you are fit to join duties now. This was issued in 2016. Sympathy is all right, but sympathy, you see, every order that we
I
pass,
may be allowed to contest.
no,
That much clear on.
can't be allowed to contest on these documents. Type of reason for absence. There are gaps which you have decided not to fill it up. They are relying on your documents. Your documents certify that you were fit to join duty. Yet there is no explanation why you chose not to join. Then if you try to run,
Our child is also having a heart disease. I have stated
whatever it may be, your
statements, man. I
your
have
statements alone will not help. You are relying on say page number 19. Page number 19. That's certificate. And this was 6/6/2016. And the documents say fit to join duty.
Most importantly and significantly, there is not a single letter from his side that to the effect that to the employer, to the effect that look, I am now
Have you made this statement in the affidavit?
yes, technically my lord. Point of any such material. There is not a single letter from his side, no document. The one and the only document from his side, my lord, is the representation when everything is over. Prior to that, my lord, there is not a single letter.
You said that
My lord, that we was
page number, paragraph.
paragraph, if lordship may be pleased to come to my lord, paragraph 5.
Paragraph.
Granted him leave. Can you see, my lord? Was granted leave for 38 days on medical ground with effect from 21/10/2012 to 8 days. Then from so and so 15 days. Then my lord again 15 days. Also granted special leave for undergoing treatment for 272 days. And listen. Then my lord 120 days. Then again 120 days. Then 32 days. Under Rule 9 of revised leave rule as amended so and so. Balance earned leave at the credit of the petitioner as on so and so was made the expiry of leave sanction yet as reflected in the order dated so and so. Subsequently, from 15/10/2015 to 11/7/2016, the petitioner was granted special leave for 268 days for undergoing treatment of TB, which is reflected from the order dated so and so passed by Director of Accounts Treasury. Then, my lord, the next paragraph. So everything has happened, my lord, with effect from 18/9/2017, paragraph 6, my lord. Petitioner was absent from his official duties with effect from 18/9/2017, and notice has been issued permanent as well as temporary address by letter number so and so, and the same has been returned undelivered. Final notice was issued to the petitioner by letter dated so and so, which is permanent and temporary address. Same also returned undelivered. Departmental proceedings against the petitioner was initiated as regards his unauthorized absence from duty with effect from 18/9/2017. So the effective date here is, my lord, which is from 18/9/2017. Prior to that, my lord, for that prolonged permissible under the law, maximum period of leave, my lord.
What is
Total period of absence, lordship will find, my lord, at paragraph 12. Paragraph 12. The date of joining of service on 8/7/2010, the petitioner herein has a long history of unauthorized absence, which is mentioned herein below. From so and so to 29 days. Now, lordship will kindly compare, my lord.
what is the other one?
The unauthorized days.
What happened?
Para number 5, lordship will kindly see, my lord. We take, my lord, para number 12, the first entry, with effect from 7/3/2011, 5/4/2011. That lordship will not find at para number 5. This is the unauthorized date. That lordship will not find at para number 5. Now, lordship again see, my lord, the second entry at para number 12, with effect from 8/3/2012 to 27/3/2012. 8/3/2012 to 27/3/2012, lordship will also not find that paragraph number 5. Paragraph, the period of leave which has been spelled out in paragraph number 5 has already been, my lord, regularized, and my lord, he has been granted leave, my lord, for undergoing his treatment. But these are the unauthorized leaves. Apart from taking those, my lord, regulated leaves from the department, the petitioner was absent on these dates also. Then lordship will kindly see the third entry, my lord, with effect from 21/10 to 2012 to 25/10/2012. 8 days. Here it is 4 days.
What it says with regard to service.
Service of inquiry report to the the refuse, my lord. It could not be served. So, my lord, yes, my lord. Lordship will kindly see, my lord, the repetition, my lord. Lordship will find, my lord, the improved order, my lord, at page 20. I may read it, my lord, from the top, my lord.
No, we are asking you whether the inquiry report.
Inquiry report is not enclosed, my lord, either with the repetition or with my affidavit, but it is available with me, my lord, in the original record, which I have secured, my lord. But we said, my lord, that we have sent in everything, my lord. Because of the fact that we have sent everything, each and every, my lord, item.
This
Whether-
page number 20. So,
without any, the letter, man. That letter
where is that?
is not annexed to the petition. I have stated that letter. I have stated, man. I have stated, man.
What was your-
Record of any such letter, my lord, in the original record we have secured, my lord.
Therefore, we are
My lord, that statements made in paragraph 6 of the repetition, we have replied, my lord, at paragraph 8 of my affidavit, wherein we have stated, my lord, that there is no record of his attending the office of the Directorate of Treasury, Assam. The petitioner did not even attend the office for personal hearing, even after issuance of the second and final notice. Termination order, my lord, that has that has not been specifically spelled out, my lord. Yes, from the record event, my lord. Because it says, my lord, in culmination of the termination order, my lord, all the notices were issued to him. In fact, my lord, the department had also resorted to for newspaper publication. But once, my lord, yes, yes. Well, to that extent, my lord, that is no. I have to be careful. That extent, my lord, there is no material, my lord. And suggested it was served on him. The declaration petition is pending, my lord. Monday, my lord. Otherwise, lordship permits, my lord. Tomorrow.
On the
and
ninth,
Ninth
ninth,
month.
ninth
Yes.
of
I'm so obliged. For that, my lord, there was advertisement, there was inspection, but there is no. That a part, it was okay. They were appointed, my lord, regularly, they're there. They said that they were initially they were working temporarily. Thereafter, one appointment letter not civil just I want to point out. That pays well. By the Joint Director Health Services, Gauhati. Saying whether the copies have not been marked to the government even or to the director. But now from October 2014, no salaries were paid to them. Then they were released by in 2017, 24/5/2017, page 52. Again, steps again. That's what there was a vision that the director, various employees of the that trial is on now. They got bail, their trial is on.
trial is going on.
Yes, sir. In the meantime, the director has page 30th of the scheme. There was an inquiry and on verification, this is the report. Just one. Page 38. The top. The dark. Salary status, salary given up to October 14 by Joint BSS Prabhat. Document submitted, xerox copy of appointment letter, xerox copy of statement. Then what you will see, the observation is very important. Appointed by Dr. A.C. Das, Joint BSS, Prabhat, right letter to this point. No records of salary from the date of appointment. Why got salary up to September 2014. At the reports of the director, because also you see the include order is page 52, which speaks about the letter of the director has a but the government order is different. So which has been of director. Apparently, my lord, there is not even a statement in the petition that they participated in the selection process. There was the advertisement, there were call letters, not a single statement. But there is a question number irregularity here. Apparently.
Then they receive their salary up to 8 or 9.
But they stated that so far as the petitioners are concerned, or they are similarly situated person, they were given in cash till 2009. That's why no record. But even if they don't care, there will be some signature in particular register. By hand, somebody. Basis for this particular letter, that is 310/2000.
Rest.
Last petition has asked to obtain certain specific instructional document, waiting for the instruction for 10 days time.
In both the matters.
So,
One matter.
5.
5. See.
Reference point is only 13, so it's not 14. And as per the revised guideline also, dental point less than 14. And also, get dental service. 105 Lordship. For 10. Evidence of dental points less than 40.
By them, my lord.
Huh?
By them, by the review medical board.
Private medical.
Done by the review medical board, my lord.
What finding regarding dental point?
It was not counted by the matter.
Now,
Everybody did, not my report.
whatever his report, but actually, so,
By the commandant, CPS, dental lordship, yes, sir. Yes, sir. 189. Dental points 30.
this is
By the
EME.
by the PSF doctor, commandant.
Hello. My dental call will be because my lord, missing teeth is left six and right six and seven. All three teeth are missing, my lord. All are molar teeth. This molar teeth having 2 points. Out of one will be molar teeth. One is molar teeth. This one will be different. Yes. Yes.
report in the affidavit.
'77. Appear before a medical examination. The RMA board obtained opinion of dental surgeon by the advice implants and oral prophylaxis. But mentioned that as
So we asked him, you said it is not a ground for rejection. Plans a ground for rejection.
as per DME, he has artificial denture and dental point less than 40. was in PME, RME losses was dental point less than 40. But as per the guidelines noted, though it does not mention that it is an unfit ground of unfitness, miscellaneous conditions, depending artificial 37, evidence of influence in situ, anywhere in bodily Apollo stated that Apollo advised implants and oral prophylaxis. But, from dental point process, because as per the recruitment rules, guidelines process,
See, the problem is he's fit. I fit enough. That's it.
How did you point out the grounds?
So if they have not pointed out, then why should we interpret this fit? Retention in the services.
Have 10 new members.
There. If it is not there, we reject it. Say this. Reject it. What can be done? What can be done?
There was no.
but
So they have 10 new members.
They've sent you, they can they compel a private doctor to give you more detailed opinion?
he has advised like, means doctor there is doctor by the FA 78 losses in our evidence. By the
That is
by system.
not the ground for remission.
Dentures
Yes, doctor.
are now.
Page
going to be-
95.
Huh?
Page 95, ground of rejection, doctor. Page, 95. Ground for rejection is number 10. Also, here, if nothing reduction of dental point, artificial dental 137. 137. Seven, evidence of 10. One thirty-seven. 137. 7. Half or complete artificial dental. DME losses, it was dental fund less than 14 and artificial dental. But in RME, it was only less than 14.
Start my. Order hearing. Regular allowance and daily allowance. Enter under supplementary rule.
Let him come back.
Venuram name.
I'm appealing for the government, but here the Jyoti Chitraban, they require to be lordship represented. Lordship government is not representing the Jyoti Chitraban lordship. It is a autonomous for the lordship. First officer also, I think, yes, not represent. Yes, lordship, RRD.
We'll
For as per number
we'll
5,
call it up again at 2 p.m.
lordship. 5 and 6, lordship.
5 and 6.
They are the main respondents, lordship.
Instruction, but not parawise comments. And as per this instruction, Lordship, we have sent, after the DME, we have sent to the higher hospital before an expert PNT opinion. And as per his opinion, Lordship, he first DME rejected him on 2 grounds, but one other problem is not found by the specialist, but one problem is found, and on that basis, RME had after
It's available on record.
yeah, no, I
Bring
can
it on record.
yes, that the form of an affidavit only this whatever the found
You are
finding
relying on the opinion of the specialist,
specialist.
but it is saying to be binding.
We sent him previously after his opinion on and we check up the petition RME board check up him and found them. Got it. That is the problem, tympanic membrane. That is some ear problem, Lordship. And that is a ground of rejection as per this. That Lordship will find that
You should.
yes. Promotional Lordship, if the document which he is relying, it's only a OPD slip of GMCH. This certificate, it's not a certificate that he is fit or something like that. That he went there and OPD slip was
What
an
is the opinion of the GMC?
After 35, annexure 7 is number 54. Tampering membranes, normal level. RT have tampering membranes is normal level. All finding in report is certified.
Sent by the department.
after rejection by the RME.
Then you have to have your report.
Yes, the report is there also. Time.
Right. Left.
Stated left hand by also founded there.
suffering from tympanic membrane. The lordship in our instruction, lordship will find that it is one of the ground for rejection. Why he was asked to submit his guidelines.
Is he
Membrane, TM, region for medical unfitness, TM, logical function. Membrane, both ears, and second one is that, but the second one we are not there because second one the higher hospital doctor said he is fit. So far the second problem is there, but tympanic membrane is there.
private hospital?
Guidelines says tympanic membrane is a reason for disqualification.
You have not mentioned that tympanic membrane is in that direction. Ground for rejection.
Right and left, there is something struck off, scribbled out.
Right stifling membranes and left left stifling membranes. Then after it like shows both normal in hearing.
Huh?
Both time.
Yes, second one,
Below tympanic membrane, says tympanic membrane intact.
index,
Before intact, striking
both
in
sides.
both sides. What is that? Striking out.
Education malat sector. Malat within the malat not only in several malat rotation raises 14 days onwards that is done. Malat. Here they raises the question why do you effort with the one is the could not be applicable now. In fact, Malat in the our academic in the position, we projected the case how he is behaving. Malat. This is not only the case. In subsequent, on the same issue, another DP was started. Here the DP was censure was given to him in our training here. In another petition, he has challenged the 14 days pay cut. That is 3410 My humble prayer philosophy. These two, both the issues are same person, same issue. Can it be take up together, so that issue can be resolved? 3410 that is a petition filed by the Anantanath, that present petition. Relating to the same issue, he is aggrieved against the posting at the 3410
Here we are not challenging the disciplinary question. Our debate is very minimal.
That yes, challenge the DP, disseminate proceeding. That is altogether different DP.
It's about his claim that he wants.
Here we in our opinion of position, we verify how while he was directed to report to that Jargaon armed force, he refuses. The higher authorities, it's a disciplinary force, higher authority direction is disputed, and he submitted a DRS application for the authority. That is also there in our pleadings. Accordingly, documents are there. Here, PI is that they are aggrieved against the where we rejected. The authority rejected his prayer to give the travel allowance.
Get much.
He immediately submitted the DRS application. That is also
voluntary retirement.
that is relevant. Why? How a disciplinary authority person behave? That is.
After a disciplining proceeding was conducted, the minimal punishment of censure was meted out to me. That I have no challenge in this petition. I am on travel allowance and daily allowance, which I am entitled to under supplementary rules. Lordship on previous occasion has went through this supplementary rule 71, which clearly says that when a government servant, a daily allowance may not be drawn for any day on which a government servant does not reach a point outside a radius of 8 kilometers from the duty point, which is the place stroke office of employment at his headquarters. That is precisely our case. If I was deployed in a place 25 kilometers away from my present place of posting at that point of time. But that's why on that basis I'm claiming travel allowance and daily allowance. It has nothing to do with that disciplinary proceeding. Even in a disciplinary proceeding document they have annexed, they are not talking about travel allowance and daily allowance. The issue was actually, Lordship, I was deployed. I preferred an application asking the relevant authorities under what law they have, whether it is under proper.
What is the interpretation at page 36? The meaning.
Lordship, this is a reply to
You're
an
challenging this order.
Yes, sir. This one, as well as there's another one, Lordship, that you will also will find at page 40. Is 19/1/2022 notification, Lordship, by which I was denied the claim made by me for travel allowance and daily allowance.
The clarification.
They are saying that, Lordship, since the deployment has happened within the same unit, that's why I am not entitled.
Page 36. Why are you telling me page 36?
Through this, they have said that I am not entitled for travel allowance and daily allowance. And thereafter, your Lordship will may kindly come to this page 40. There are 3 euros. The application of the individual was examined and the same has been disposed by the IGNES headquarters Gauhati by letter number so dated 19/1/22, stating that such type of TADA claim is not allowed and admissible in accordance with provision enumerated under supplementary rule 70 and 71. That is the case. The language of supplementary rule 71 and 70 is absolutely clear. Here, perusal of it will go so that I am absolutely entitled
Where is 70, 70?
Supplementary rule. Correct. Talks about 8 kilometer of radius.
How is it stay?
Federal sector, the armed center is Jurgaon, armed center is persons, the CISF personnel were periodically deployed to that place, 14 days. Of course, senior CISF persons, why he is behaving like that is not known to us, but as per that SR 70 and 71, within the
the same sector, mother. His sector, if the place of posting at Juliajan, he have to go to that, mother, not only him, mother, the periodically persons were deployed there, mother, 14 days for at a mother time, mother. So he is agreed against that. That is why he is claiming that he want to have that TNDA. Here then, under that subsidiary rule provision is not applicable here in the instance case because it is within the same mother place of posting.
Okay. These are both different sectors. Okay. I can show it from their document itself. Okay. I was initially deployed in industrial sector. Thereafter, I was deployed to field sector. The distance between field sector and industrial sector is 25 kilometers. Okay.
Now, please explain SR 70.
Yes.
SR 70.
That's what I mean.
Yeah.
Daily allowance may not be drawn for any day on which a government servant does not reach a point outside a radius of 8 kilometers from the duty point, which is the place of office of employment at his headquarters. Then going by the argument that the same unit you're
No, no,
located,
no.
or return to it from a similar point.
So, yes, SR 71.
That
That if they
that was in industrial sector. You're also. Initial,
that mean, sex.
thing you're looking. Temporary point you're looking. That
71 in there.
if may kindly come to
It says that does not reach a point outside of India. I, where you are required to travel from airport.
my humble something. Okay. I was deployed in industrial sector as a head constable. Okay. That would be my
Let me
duty point. Okay.
let me share.
That's what I'm submitting, Your Worship. I was posted in industrial sector, Your Worship, and I was given government quarters there. That is the main sector which I've been allotted, Your Worship. Now for temporary deployment, they sent me to field sector. That's what I'm submitting. My point of duty is that at industrial sector.
Show us the deployment order.
Okay, I can kindly come to their affidavit in opposition. Kindly page one point. In page 45 of the affidavit in opposition. Para 4, page 45. They stated that as per practicing work, he was deployed at Georgian magazine outpost of industrial sector. That is what they have stated.
Para?
Para 4 of page 45 of the affidavit in opposition.
Roman 1, mother.
Roman 1.
Or
As
Roman 1.
per
Last part, mother.
as per practicing work, he was deployed at Jordan Magazine outpost of industrial sector for 2 weeks with effect from so and so year. But that is not. What you may kindly come to page 70 of their affidavit of police. That there was a disciplinary proceeding which I am not denying.
70.
70. Now, point 3 here. That's their document. Okay? That inquiry officers line. The undersigned, going through records available with the case file as well as representation submitted by the judge official, found that on 16/8/2024, AC PROCEEDINGS Anantanath was deployed at Jordan outpost under field sector. Now, at one hand, they are saying that he was deployed at Jordan Magazine outpost of industrial sector. But that is not the wrong submission. The para 3 of their,
That's all right. Whether it's X1 or X2.
that is what I'm submitting. Okay? That is there, Your Lordship, in supplementary note 32.
Says you are not covered under, you are not entitled to exercise.
I will try to get that original.
Enlighten the court as to
There's a personnel were deployed to that Jordan, that point mark. That is within the same sector. That is our stand.
appearance of same sector or the sector.
Okay.
Says that you are to go from same sector or different sector. Okay. You have to tell us where is this beauty point.
Persons are deployed there, Malad.
Goswami, please understand. The commanding side where these personnel are to be placed. Next, area.
I would like to point out if Lordship permits me. Lordship, I have annexed one finance department notification as well, rate petition, where it says that as per rule position as mentioned in SR 71 of FRSR, travel allowance for a local journey shall be admissible if temporary place of duty, here is temporary place of duty, is beyond 8 kilometers from the normal place of duty. That is what I'm submitting. Industrial sector is my normal place of duty. I was deployed in field sector.
You show us by which orders we are deployed.
Or I will get those orders.
You get it
I will
first.
try to get those. That date means
It's 127.
Reduction of basic pay of monthly pay.
Reflected in here. Why not? Protected in why not? Yes, my lord. Then will be responding.
Pale rako dekhe, Lakshmi kam only come 44. There are two sub-para B. In nutshell, we put it. Petitioners were engaged in the year 2010. Case of offenders provided for a full scale of pay only to master role workers, casual workers, and not contractual workers, like the present petitions. Otherwise, also for one to be eligible for minimum scale of pay as per Upenda, the worker has to have been working for more than 10 years as on 1/8/2017. Para 22 of Upenda. The petitioners herein having been engaged on 2010 has not fulfilled the above condition, as from 2010 to 1/8/2017 it calculates only 7 years approximately. It's not
Then
10. So as per Upenda's, one has to have 10 years or more before 1/8/2017.
can you then tell me?
I don't think-
IGLP 605.
Paragraph 22 be kindly.
Central I limited Read para 22. Read para 22.
do not have copy minor.
It's however heartening to learn that state government has agreed not to terminate the master role, work choice and similarly placed employees working since last more than 10 years, not in sanctioned post, till their normal retirement, except on disciplinary ground or on ground of criminal offences. The state government has agreed to enlist such employees in health and accidental and death insurance scheme, which will be prepared in consultation with the state cabinet. We appreciate this positive stand of the state government taken as a welfare measures for the betterment and security of the employees in question. We accordingly direct the state government to implement the measures without further delay. Besides this, we, in light of the decision of the Supreme Court in state of Punjab, said Jagjit Singh Surenso, also direct the state government to pay minimum pay scale to the master role workers, 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 and similarly placed employees working since last more than 10 years, not in sanctioned post, with effect from 1 April 2017.
2017 it is mentioned for giving benefit year on. With effect from 1/8/2017, benefit will be given.
Right?
This was the date when this judgment was.
Judgment was delivered on 8/6/2017. What? More than 10 years.
10 years.
One
On what
April.
protection basis?
On
Yes.
protection.
Why are you engaging them on protection?
They can be engaged. This was they engaged under scheme, not Manrega scheme. For doing those works, necessary works for implementation of the scheme, they are engaged. Their contract is usually for 1 year.
No, they are now.
Under a Manrega scheme, it is not under the department.
Manrega scheme.
When it is accredited engineer, they usually assist in the process of implementation of the schemes in
This scheme is still going
Manrega scheme is still on.
For a moment, kindly come to page 41. Of what interested to us that with the other yes, in the Panchayat and rural. Junior engineer employed in the under the Panchayat Rural and Development Department. Then page number 14. Order number 12. And for a smooth and efficient implementation of different rural development programs, that and regular are hereby entrusted with dealing of technical part of all rural development programs. Gaon Panchayat has shown you. Why not the work entrusted to us same as the work entrusted to the other junior engineer regular.
and then you designate
May I sign, my lord? May I submit, my lord?
Sound is not coming, probably.
May I submit, my lord?
Please.
My lord, this IA, my lord, is a for condonation of 130 day, 3 days, my lord, delay in filing connected review petition, my lord.
On the other side,
Pardon, my lord.
am I audible?
Yes, my lord.
audible.
It out.
Mr. Counsel, you're representing the applicant.
No, my lord.
And who's for the other side? Anyone for the other side? I see the other gentleman there.
He is
I-
petitioner in person, my lord.
I am appearing as opposite party.
Opposite party in person.
Yes. Appellant in person in main case.
Seeking a review.
My lord. Review of the order dated, my lord, 3/9/2025, my lord. Pass in W. Read appeal, my lord, 5 of 2023, my lord. IA, my lord, is condonation of delay of 133 days, my lord, in filing the writ.
We'll issue a short notice, but
My lord.
subject to correction, I don't think delay petition is necessary for filing a review. I think there is a judgment of this court also.
My lord.
May not be a hurdle in filing, but we'll issue a notice here. Yes, brother.
My lord.
Yes.
We'll issue a notice.
May it please your lordship?
Yes. We are issuing a
Uh,
notice. You file your objections if you have any. You file your
My lord,
objection.
my lord, I have objection.
You have to file your
what-
objections.
Okay, okay, my lord.
But,
No, I am not filing till today.
all right. You file it. We are giving you an opportunity. 3 weeks. But
Okay.
the counsel for the applicant. This IA has been filed seeking condonation of delay in filing the company petition.
My lord, short date may be given.
3 weeks.
Oh, no, next week.
Next week. You will
1 week.
file it next week.
Yes.
Then we'll have it on 20 March. Yes, brother.
Okay, my lord.
Obvious, my lord.
It's 20 March.
Obvious, my lord. Okay.
Where's Verizon? Got it.
That the order my garnishment has supplied to me. Can I read that?
But there is no stay in that single business order.
May not be, but the matter is pending.
Yes, my lord. Matter is fixed on 25/3.
Let it come after. Counsel for the respondent has referred passed by coordinate bench in WPC
WPC 4407.
WPC 4407 of 2023, which according to disposed of a petition, similar issues were raised. So, so ordered by writ appeal is fixed again on
25/3.
25/6. Accordingly, this court is of the view that the matter should be listed. Stop it. The court regarding the such order that will be passed by. Yes. Yes, what do you say? Is it covered?
And already affidavit has been filed, admitting that they have already given.
For the respondent here? Say regarding the judgment?
Okay, I have no objection, but my only concern is that what
For 5 and 6, this.
Sati Chitravan and Lordship and Secretary.
Yes, then
So I have no.
you have no objection. Matter stands covered.
But on the
There is a direction by in this judgment to the state government to arrange for funds. There are 25.
the affidavit also they have admitted. Paragraph 8.
That is the direction, madam. Para 25. Heard something for parties disposed. Your Mr.
M. Boru Lordship for R. Ali.
M. Boro for R. Ali. M. Bhattacharya for the state. Disposed.
5 and 6.
What submission? Submission. First similar order, there is the direction.
Yes.
Suffice.
Oblige.
Yes.
Fair occasion, the DLC rejected my proposal on the ground of 4 years delay in submitting of application.
Yes.
But that part, when I submitted my application in 2015 itself, that part it was suppressed by the department. And when the Honorable Court repeatedly pressurized to bring on record of the whole, bring on record of all these these petitioners' documents, then subsequently they have come with the affidavit saying that no, yes, we have found that in 2015 this application was submitted. Now they have considered, and that my lord, this suppression has been continued since the date of filing of the writ petition as on date. And recently now they have filed the affidavit saying that this application was filed in time. Lordship, kindly have a look, my lord. Immediately after my father was expert on 3/8/2015, Lordship.
Yes.
And the petitioner got accident, my lord, on immediately after 15 days, my lord, on 18/8/2015. As a result, my lord, he has been permanently disabled for 50%. That certificate I have enclosed in the writ petition. And my lord, since the petitioner was under medical treatment, meanwhile the petitioner's mother submitted an application on his behalf on 5/10/2015. Thereafter, the DLC district level committee meeting was held on 9/8/2019, stating that my application was submitted on 6/6/19. So there is a delay of 4 years, and accordingly, my proposal has been rejected. Lordship, kindly have a look the rejection order. Before that, my lord, Annexure 2 is my disabled certificate, my lord. Annexure 2, Navajit Bhagavati, the 50% disabled, my lord, after the father's death, my lord. And my lord, the circular, my lord, regarding the absorption of the disabled persons circular 6 January 2020, I have enclosed at Annexure 3. Now, Lordship will find
What is your disability?
the left leg, my lord, that.
Where is the DLC recommendation?
Lordship, kindly have a look, my lord. Before that, my lord, my application, my lord. My application, Lordship will kindly see Annexure 8, page 27, my lord. And 28 is vernacular. 28 is vernacular. They have received it by endorsing, my lord, on the top. Then Lordship will find they are all these documents there. Then Lordship,
When did your father expire?
my father was expert on 3/8/2015, and the petitioner got accident on 18/8/2015 after 15 days. An application was submitted on 5/10/2015. In 2 months, the application was submitted. Then Lordship will find,
How old were you on the date of submission of the application? Was your age?
now,
On the date of submitting the application?
date of submission. That 34 minutes. 34, page 34 minutes. Format was submitted later. School certificate minutes. I passed the higher secondary in 2012. Nityananda Chaudhary Institute of Management of Technology.
Then what is the DLC?
DLC Lordship kindly have a look at start from 45 Lordship. Minutes of the DLC mallet. 45 NHR 16 and relevant portion mallet 46 mallet. Down below. Navajit Bhagavat. Here mallet the date of death is 15 and the date of application has been shown 6/6/19.
Then what happened?
And now Lordship will find the remarks mallet.
So we've seen that. Then thereafter you came to the court.
Yes,
Ah.
because
What was the order passed by the court? So your case was not considered in view of page 46.
and my lord, that order, as if there had been any rejection, my lord, that had to be communicated as per the office memorandum dated 1/6/2015, my lord. That has not been done. Then I have come to the, I have applied for the copy, my lord, at page 47 RTI, my lord, my RTI in 2024.
And what happened?
Then they have submitted this minutes and all money on the basis of that. On the 24, when I have come to know, then I have approached before this honorable court. And Lordship knows that 1/6/2015, last 56 page, my lord, page 56, last D. This is office memorandum. While disposing of the application by way of rejection, here speaking order shall be recorded, stating the reason of the rejection, and a copy of such order shall be furnished to the applicants. That has not been done. That is why I made the RTI application. When Metro was was
No, you come to page number 44.
That's it.
The applicant is your mother.
But they have shown when I was under the medical treatment, the applicant has been shown by them. The candidate is Navodit Bhagavati, applicant Minu Bhagavati. Minu Bhagavati submitted the application. Then this 6/6/2019 is itself a suppression of right, because in earlier occasion 2015 I have submitted that part. Now they have considered by filing the second affidavit.
Where is it?
Their second affidavit, the first affidavit. Second affidavit, it was filed on 12/11/25. Paragraph 5. That the deponent stated that the office of the undersigned received the application dated from the mother of the petitioner on 3/11/2015. Now they have admitted. Then first one I will show before Lordship. The same was traced back in the receipt register of 2015. That from the perusal of the letter dated 3/11/15, it is seen that the mother of the petitioner applied for compulsory appointment on behalf of the petitioner, which is an admitted fact by the petitioner in the petition, more specifically at paragraph number 7 of the. Now they have admitted that the application was submitted.
For this
And-
DHE.
And earlier, their affidavit lordship kindly have it.
But then, in view of the subsequent affidavit, your rejection appears to be incorrect.
Compassionate appointment application by the mother of the petitioner. That is why in the first application it was said that it was in 2019. So 2019 also one application was
You
received.
consider it then. Reconsider it.
Can be reconsidered.
Yes, Mr. Chetri.
Yes.
Council. Yes. petitioner was undergoing to submitted respondent part. Subsequently, final RDA
7 nothing. The reply was furnished to me. RTI application was dated 13/3/24,
rename
13/3 nothing. 13/3/2013.
pursuant to which the office of the executive engineer AG submitted a reply by the dated 10 see respect of the minutes which was enclosed to the reply filed by the furnished by the department. It is seen. Petitioner case was rejected, that his application was filed 6/6/2019. So it's filed file.
My lord, it was rejected on 9/8/2019.
When did you file your application? When did your mother file your application?
The 6/6/19. Before that,
6/6. 5/10/2015.
5/10/2015,
2015, the
And-
application was filed
and the last one 6/6/19.
on behalf of petitioner by his mother. See, so later, the mother again filed another application. 6/6/2019. So this subsequent application, which was considered when the application filed by respondent department filed. Six to government. Application file. Such circumstances. Stop.
5/10.
Huh?
Acting.
5/10/2015. That's a long dispute. Civil period. So, expired on. When did he expire?
He expired on 3/8/15.
3/8/15. It's filed by his mother. 3/10.
5/10.
5/10/2015. So, this application. See, by the department. Specific environment. So, it's unequivocally scored. See. The application taken promotional report. 6/2009. To be statement. It's true. 6/6/2019. First application. 5/10. See, ID.
Even 7/19.
By the minute stated 11/7/19. Where do you find the date?
Submission. 45. Sorry. 45, 31, 10, 19 law. Case 45.
No, 9/8/2019.
No. That is different law. 45.
9/8/2019 is the date of the minutes.
Yes. Yes.
They will consider.
They will consider.
Only my prayer.
Prior to the recent development. Consider it. Parameter.
Clause 15 of Office Memorandum 1/15. That is that now recently for a lawsuit recently 12/12/2025 one compassionate appointment clause 1 of OM dated 1/6/2015 that was set aside by the government. Yes, state government filed appeal, but the division bench upheld the single bench. And
But
being
there is
thereby,
a direction
the
also.
development
Lord.
of the theory and all these things were considered, and audit this Canara Bank case 2025 that has been considered. I'm saying that since only delay factor would be the person is not filed his application within that time
In
period.
your case, it is not applicable.
Yes.
Why are you making all this submission?
No, that's what
And if that was not applicable.
No. In your case, in your
Yes,
affidavit,
yes.
it is within
I
time.
just informed you before this.
We are
No,
just-
in fact, the Canara Bank has gone for, it has been referred to a larger bench,
Canara Bank.
Canara Bank. Well, I'll just hand over what
That part.
the issue here falls that when it will be considered which rule has to be taken into account, the rule prevailing on the date of consideration or the date of application. That has been, that
That
Canara
part
Bank has
is
gone to,
fine.
no, that has gone to larger bench.
That part already.
But until larger bank decides.
Yes,
Not really apply.
yes, date of consideration. But that is different.
Here is the case, this is the case where the date of consideration.
Yes, yes, agreed.
For the simple reason that it is wrongly considered.
Well, that's a different issue altogether.
It has been a case that was
Considered as part,
it was already pending and was not considered, then perhaps.
that's a different issue.
the later rule.
Not problem. Not problem. Problem.
MSM Bhattacharya.
Sorry, let him. 5/10/2000.
Challenging here.
For a 5/10/2022 for compulsory retirement. That's what the department.